Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. One of our subscribers, Max I think is his name, has asked me to make a video about non-disclosure agreements and whether they hold up in court if you breach them. So I thought we'd explore that today. A non-disclosure agreement is a legally binding contract that basically sets forth a relationship between two parties. Now, that can be two businesses that are going into a relationship together. It could be an employee and an employer. I mean, literally the range of people who can enter into non-disclosure agreements is fairly large. But basically, what happens is one party agrees to share confidential or sensitive information, sometimes even trade secret information, and the other party agrees not to make improper use of that, not to disclose it. And in India, it can also be referred to as a confidentiality agreement. Now, the purpose of the agreement, of course, is to protect the information. And in order to do that, it has to be a legally binding contract. And in order for it to be a legally binding contract, it has to meet the requirements of contract law. There has to be an offer, an acceptance, there has to be consideration, the terms have to be definite enough to be enforced, and that's really all you have to do. You have to get the things in there that need to be in there. And once all of those elements are present in a non-disclosure agreement, it is enforceable. That's why non-disclosure agreements, and very much similarly, covenants not to compete, are things that I tell clients not to sign ever. I realize you want the job. I realize they're offering a nice pile of money to get you to come to work at that job. And I realize that in order to protect their best interests, they want you not to compete with them for 2 years and to keep all their business information separate and secret. But the problem with it is that going into a relationship, you have no idea how the relationship is going to work out. And you don't have any idea how you're going to feel about people if the relationship ends. And so rather than give the other party an opportunity to sue you for claimed violations of an agreement, the better thing to do is not to enter into it. Now, it used to be that people would respect an employer's property and they would consider things like customer lists to be the property of the business. And they wouldn't take those kinds of things because they had integrity. But in the last few years, we have seen a lot of people do things that are just pretty skeevy. And so it makes sense that the business wants to protect its information. But the reason that I tell people not to sign these agreements when they bring them to me and ask me to read them is because if you are asking me to read them before you sign them, I'm just going to argue that you shouldn't sign them. If you are worried about maintaining confidentiality because you think you might be able to take something from this business, I'm not going to be able to help you. On the other hand, if you're bringing it to me afterwards, saying, I really need to use this information that I learned while I was at Company X, and now I've got this non-disclosure agreement and I want to get out of it, I can't help you if there is not a reason to attack it under traditional contract law. Now, non-disclosure agreements are common for businesses entering into negotiations with other businesses. The folks share private information, and they can do that without fear of the information falling into hands of competitors. In that situation, it's called a mutual non-disclosure agreement. But there is also the non-mutual non-disclosure agreement. A lot of companies require that new employees sign an NDA if the employees have access to information that might be harmful if it was released about the company. And I've mentioned it several times, but customer lists are high on that list. The other things are proprietary processes. There are things that you learn when you go into a business that are proprietary to that business. Not all of them are sensitive or confidential because they've already been duplicated by competitors. Nonetheless, you do learn certain sensitive information, and if they want to protect that information, they will ask you to sign a non-disclosure agreement. So asking you to sign, there's your offer. You saying, okay, I'll sign, that's the acceptance. And the consideration, the value that the company gives up and that you obtain is, in fact, the job that you are going to get and the payments that they are going to make to you by virtue of doing that job. Once you have all three of those things, you have a valid contract in most cases. Now, not every employee in a company is asked to sign one of these non-disclosure agreements. But for example, if you work in the part of the company that involves maybe strategic planning or human resources, the last thing in the world you'd want to do as a human resources person is to reveal sensitive information about certain employees. And so you'd be asked to sign a non-disclosure agreement in that situation. Now, if an NDA is breached by one party, the other party can certainly seek court action to prevent any further disclosures. There are a couple of things that can happen here. You can be sued for monetary damages. In other words, the actual cost of what your leak of that information caused to the business. Now think about that. That could be pretty significant. If you worked for a bank, for example, and you mentioned to somebody at a party how they handled wire transfers, and then somebody used that information to fraudulently induce the bank to wire money somewhere, you could be on the hook for a lot of money. So the monetary damages is one thing. There's another thing called liquidated damages. Liquidated damages are for things that you really can't necessarily put a price on, like reputation, that sort of thing. So, for example, in that situation, it will say something to the effect of, because we really can't estimate up front what it would cost if you breach this agreement, you agree to pay us $250 a day for every day that this information is out there in the public, up to a maximum of $250,000. That could be a really severe penalty for releasing information. Now, if it comes off as a penalty, most courts won't enforce that, and they will require the plaintiff to prove the actual damages. As long as it's not interpreted as a penalty, then usually the liquidated damages clause will hold up. Now, another thing that these agreements tend to have are choice of law and forum selection clauses, which we'll discuss a little bit more in a moment. But for example, Twitter's terms of service used to require that any action be brought in California, in the district of where San Francisco is. And they required it to be brought in federal court because federal court is very, very friendly for corporate sorts of litigation. National companies then can get the benefit of their local counsel. So if you go to work for a big company like, for example, Quick Trip Corporation, if you were to go to work for Quick Trip as a manager and you were given proprietary information and you breached that agreement, their headquarters, I believe, is in Atlanta, and so they would apply Georgia law, and they would require any action for you suing them to be brought in Georgia courts. And if they decided to sue you, there would be a provision in the non-disclosure agreement that says you agree to waive a choice of venue, or you agree to the venue and jurisdiction of the Georgia courts. So you can, in those situations, waive any defenses you might have. So the other problem with these non-disclosure agreements is that they tend to extend well beyond the date of termination. So just because you quit working for Apple Computer on Friday doesn't mean you can use their client list on Monday. Usually these agreements extend for a really long time, and that's especially true with trade secrets. So the agreement is going to list the participants of the agreement. In other words, Company A and John Doe agree to the following terms and conditions of employment and non-disclosure. And then it will designate every party that is involved. Now, a lot of times what happens is you have companies that work sort of through different corporate structures. When I worked at Blessing Hospital in Quincy, Illinois, the hospital was one corporation, and then the nursing school was another corporation that was attached. And in addition to that, the medical equipment company, the durable medical equipment company, was a third, called Denman Services. If you signed an agreement with Denman Services, it did not bind you to anything except Denman Services. So you were free to discuss the confidential information of the hospital. So normally what they do is they do an agreement where they name the parties and the entities for whom confidential information may not be disclosed, and they do that at the very front of the agreement. And they designate them specifically so that you can't later come in and say, well, I thought I had just signed this agreement with the hospital, and I didn't realize when I talked about how this medical equipment company worked that would cause me problems, because it will be spelled out in the agreement. And of course, everybody gets a copy of that agreement when they sign it. And in addition, there will usually be a definition of what is confidential information. In other words, they will specifically list things like customer lists, proprietary procedures, and processes used by the company. For example, how Heinz makes pickles or how Heinz makes ketchup. All of those processes and all of the confidential information will be spelled out in category form in the agreement. So they're not going to say what the specific formula is that's protected, because that would be pretty stupid. The minute that they filed this agreement in court, it would be revealed. So they can't do that. Another thing they can do is they can say anything that has our confidential information stamp on it is considered to be confidential information. And then they'll usually say something like, just because the confidential information stamp does not appear doesn't mean that it is not confidential. It is confidential as long as it belongs in any of these following categories. And again, they would list the categories. Now, sometimes what companies will do is they will take the exact opposite approach, and they will say, everything that you learn in this company is confidential, except the following. And then they will list some generic things like, for example, the location of certain units within the hospital, or the location of certain items within the plant, like where the fire extinguishers are. That's not confidential information. The names of your fellow employees, that's not confidential information. They will try to exclude everything except things that they really want to protect. Now, the problem with this approach is that it is often overbroad. In other words, it will loop in things that if you sit down and depose the CEO, and you will say something to the effect of the brand of napkins that you use in the cafeteria, is that considered confidential? Well, no. But you put in here food preparation and service items. That's certainly a service item, correct? Yes. But it's not confidential, is it? No. So you would agree with me that that's excluded from the agreement. Well, yeah, I'd have to agree. And as a result, it's sort of the death of 1,000 paper cuts when you go to challenge one of those agreements. And essentially what happens is the court may at some point decide, well, this whole thing is just very overbroad and therefore unenforceable. Now, the other thing that has to be in there is the time period, which is going to specify how long the party is bound. When you're talking about confidential information like customer lists, the normal period of time is between 2 and 5 years. Because, again, the customer list is going to turn over multiple times within that period. Trade secrets, on the other hand, are protected forever. So, for example, the marketing division's belief that in 2024 they are going to sell 50 million units of Coke, that might be confidential information. But the recipe for Coca-Cola is a trade secret. And it's not only protected by an NDA, it's protected under the Uniform Trade Secrets Act. And in some states, there are even criminal penalties for violating trade secrets provisions. As I mentioned before, they're going to have this choice of law provision. You agree that Georgia law applies. You agree that Alabama law applies. And particularly in big business, you agree that New York law, Illinois law, California law, and with regard to credit cards and credit card companies and banking companies, South Dakota law. And all of those are chosen for the specific rights that they give that entity in that particular state. So a choice of law provision is going to be in there. A choice of forum. You can only bring this action in the Middle District of Alabama, and or you can only bring this in the state court for Jasper County in northern Alabama. Anything that lays out where the case can be brought is called a forum selection clause. Generally, these are held to be valid. Now, a jurisdiction clause where you agree to the jurisdiction, again, the courts usually say you cannot create jurisdiction by agreement. But unfortunately, when you're talking about a contract, the place of where the contract is negotiated and executed will usually control for the choice of law and the choice of forum and the venue. And many of these agreements also include mandated arbitration or arbitration agreements where they say any dispute about the terms or conditions of this non-disclosure agreement must be submitted to arbitration. So you're sort of locked out of your state and federal courts in that situation. Liquidated damages I already talked about, but injunctive relief I haven't talked about. Injunctive relief is where the court will say to you, you will essentially agree that you can be enjoined. You can be enjoined from releasing information further. They can require you to return all the documents in your possession that have any relationship to that particular company. There are all kinds of things that can be mandated through an injunction that don't go to monetary damages. So what happens if you break a non-disclosure agreement? Well, then you're going to be susceptible to the consequences outlined in the contract. So if you have a liquidated damages clause, you're going to be subject to liquidated damages. If you have an injunctive relief clause, you're going to be subject to that injunctive relief. Now, all of those things have to be proved, and the agreement has to hold up in court. But as long as it's reasonable, the time period is reasonable, the things that are covered are reasonable, the document is not overbroad, then in most cases they are going to be upheld. And the reason for that is because courts want to recognize and give credence to the agreements that people make. And they're not going to allow someone to take the benefit of 2 or 3 or 4 years employment working for somebody, learning that business, and then taking the confidential and proprietary information and starting a business of their own. So again, if you sign a non-disclosure agreement, in most cases, you are going to be bound by it. So what do you do if you really want this job and they've offered you a job, but they want you to sign one of these agreements? Well, if you are uncertain, do not sign the agreement. These contracts are routinely enforced against employees, and if they won't hire you without you signing one, you need to remember that not all jobs are worth the hassle. You are going to be bound for whatever period of time the contract specifies, and well beyond the point where you have terminated employment with this particular employer. It's going to open you up to a number of different lawsuits, none of which will actually be good for you. You can also be sued for intellectual property violations like copyright infringement, and you can be sued for a breach of fiduciary duty. There are a lot of ways that these can be enforced, and again, it's only enforceable if it meets the requirements of a contract and it's specific enough for a person to determine whether, what is protected and what is not, and the time limit is reasonable. If you have signed one of these agreements and you now wish to get out of it, you need to go see a lawyer in your jurisdiction, have him read the document, and have him tell you what he thinks your chances are if you were to breach the agreement. Because without that information, just going on ahead and breaching it can be very, very detrimental to your long-term financial health. And it might get you in trouble in a number of other ways. It might actually make you unemployable in the industry. Because if you are thought of as somebody who takes trade secrets or proprietary information away from other businesses, most other businesses in that line of work are simply not going to hire you. Those are all things that you need to consider. Now that's what I have for you today. I wanted to point out that my t-shirt here says that people who tolerate me on a daily basis, they're the real heroes. That's for my wife. She's my real hero. Thank you so much for being here. If you have any questions, leave them in the comments down below. Like, share, subscribe. You can email me at the address up above. If you have the opportunity today, do something nice for someone. If you go to the grocery store today and you see somebody has left the cart out in the middle of the parking lot, do everybody a favor. Take that cart and take it all the way back to the store, or put it in one of the cart corrals so that somebody's car doesn't get banged up when it starts rolling and smashes into it. That's just the nice thing to do, and it's a great way to make the world a better place. Again, thanks for watching, and come back here and catch me at the beach again next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.